Mr. Gopal? This, who's the one that we have? Who's this one?
That's Mr. Davis.
Mr. Davis. Okay, let's go on the record in the matter of the state of Michigan versus Todd Davis, 232204. And appearance, counsel?
Right, for the record, John Gopal, P 30758, on behalf of Mr. Davis. Mr. Davis, would you please put your name on the record?
Todd Davis, Your Honor.
All right, and sir, you can hear and see your attorney, correct?
Yes, I have spoken with him, yes.
Okay, you can see and hear him okay on the screen here?
Pardon me?
You can see and hear him okay on the screen?
Yes, ma'am.
Okay. So you seem to be having some issues with your hair. Can you just tuck it behind your ears?
Yeah, they took my tie and, yeah.
Okay, that's fine. That's fine, it's okay, all right. All right, counsel, as to the arraignment.
Your Honor, I went over the charges with him. He would stand mute to those charges, waive a formal reading of those charges, and ask for plea of not guilty to the indictment. Was charged with operating while intoxicated second, as well as while license suspended second.
All right, the court will waive the formal reading, enter a plea of not guilty for purpose of the arraignment, and we will schedule this matter for a pre-trial on October 19th. 9:20 a.m. Counsel adds to bond.
Your Honor, as to bond, Mr. Davis does have a prior criminal record, including obviously an operating while. He is presently unemployed because a couple of months ago, he was a victim in an armed robbery. He was shot in the shoulder, and you can, if you visited in the jail, you'd see the scar and all the surgery. He is presently residing with his family for support. The reason for his unemployment is because of his wounds, and he's recovering from surgery. In fact, he has physical training scheduled for Thursday, and also has pain management scheduled for next week in Bureau. The physical training is at the Henry Ford facility here in Wyandotte. He's resided in Wyandotte for about the last 8 years, I believe, and he's not on probation or parole at this time, and he has never missed any type of a court date throughout even all of his other matters that he's appeared in court when expected. He's also been in contact with the prosecutor regarding the case now pending as him as the victim, and they are scheduled. In his contact, he's been informed that they are taking that matter to trial. I bring that all to your attention.
I'm sorry, which court did that, was that in this court?
No, purchase.
I understand that, but it had to originate somewhere other than Third Circuit?
I didn't
Because
answer.
Mr. Davis seems very familiar to me.
And he does have some prior, I don't know if it did or not, Your Honor. Mr. Davis, where did the matter that you're the victim of occur?
Oh, in the city of Detroit.
So it must have come out of the 36.
Sir, have you had cases here before?
I have been in front of you. You know, fortunate for me, them cases were dismissed, and I don't have anything active in front of you at the.
Okay. And were those cases?
Yep.
What
No,
was
I
the
am
nature of
on
those
the.
cases? Was there a domestic violence? Is that what one of those was?
Yeah, I stopped messing with Miss Stevens. We don't talk to each other no more.
Oh, there's some things I just don't forget. I don't know why. That's true. All right, well.
Your Honor, also he's on medication because of his injuries, and he has not been provided with those medications for quite some time. We're asking for a reasonable bond under these circumstances. He's asked for a personal bond, however, Your Honor, obviously with an alcohol test. No, his record does not support that. However, the personal bond aspect. However, because of his other circumstances, injuries, his inability to work at this point. They're asking for personal bond with an alcohol.
And I
The
understand.
alcohol. May I say something? Yeah, if I am placed on tether, I'm gonna be I will miss my physical therapy this week because now I will have to go down to the Wayne County Jail and sit there. Last time I went there for a tether, I was there for like 14 days waiting on a tether, and I don't have no medication. I have a plate with 13 screws in my arm. I have physical therapy this week, pain management here coming up Monday, and there's possibility that I won't even be able to make my appointments because I will be sitting down in the Wayne County Jail if I was to get a tether.
Okay, and sir, I can understand all that, but at the end of the day, your actions are why you're here, not anybody else's. You don't have a valid license.
Yes,
Even
ma'am.
operate a motor vehicle, and
I don't even own a vehicle.
you have a prior conviction for alcohol-related driving, so you know at what point you feel a certain level, and you know when you shouldn't be driving.
DeSantis, I understand. I swear I understand that. Actually, the vehicle that I backed up because it was in Wyandotte here, it was at the riverfront, and I had backed it up for the person.
Sir, we're not gonna have you talk about your, about the allegations. I'm just bringing to your attention that if you don't make those, that's not on the court. That's on your own behavior. So what I'm going to do is I am going to indicate a $7,500 10% bond.
I don't have the
In the
money
event bond is
for,
excuse me.
I don't have any money. I swear, I don't have no money. I'm now about to sit in jail. I don't even have pain medication there. Oh my God. I'm gonna miss all my physical therapy. I am in pain.
Sir, I can understand that you have some pain. Sir, here, at the end of the day, sir, you're not even to be driving, and you were driving, it's alleged. You also aren't supposed to be consuming alcohol and then driving, which is alleged. So there are some concerns that this court has for the safety of the public.
Ma'am, I'm not a threat to the public. I am not a safety, a friend had came over. I don't even leave the house because of this.
Mr. Davis.
One time I left the house, DeSanto, I swear, I don't have any money.
Sir,
I don't.
Sir, if you have, listen, let me explain this. If you have medication that you need, you can have somebody in your family bring that medication up.
Family, only family I have is my mother. She's unemployed. She don't even have a vehicle. She's in her 60s. She can't even get it down here because she don't even, I do everything for her to pay the bills. As far as cooking, I try to do as much as I can. She's pretty much old. She can't do nothing. And now I'm sitting.
That doesn't make her old, sir. She's pretty much old. She's in her 60s. That doesn't make her old. Sir, we're done. $7,500 10% with an alcohol tether through the Wayne County Jail. Thank you.
Thank you, Ron. And you said that probably.
Next Thursday. Yeah, I think I said 9:30.
Can I please have a personal bond, please? Please.
Mr. Davis, come on.
$750. I don't even have $750.
Very right.
What are we doing today?
It's a plea, counts 1 and 2. There's no agreement, Your Honor.
22-40113 is now called. The state of Texas versus Ruth Johnson. There's a motion to revoke probation filed on September 1st, 2023. You, Ruth Johnson.
Yes, sir.
And you're here, your attorney, Mr. Dusler. Raise your right hand, please. Your other right hand, God bless you.
Sorry,
There
I'm so
you go.
sorry. I'm nervous.
That's okay. Do you solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Does the defendant waive a formal reading of this? Can we proceed in?
Yes,
summary?
sir.
In summary, this motion states that on January 23rd of earlier this year,
Yes, sir.
you were sentenced to 5 years in prison, probated for 10 years, regular probation, for the third degree felony of unlawful possession of a firearm by a felon.
Yes, sir.
Is that true?
Yes, sir.
Counts 1 and 2, Your Honor.
Mhm. Number one, state you failed to report to the probation office on or about February 7th. Hold on. That was 2 weeks after we put you on probation. Then
Explain that.
February 16th, April 4th, April 20th, and May 9th of 2023. Is that true or untrue?
It's true, but I caught COVID. I'm sorry, I wasn't trying to, and I did call the people at the probation office and tell them that I was sick.
Let me ask the probation office, did she, was she an absconder?
Yes.
Okay, when did she last report? And you're Miss Rogers, right?
No, I'm
No?
Bill, I just,
Oh, you did? Okay. Miss, what happened to,
I got a new probation officer too in the midst of getting.
hey, things work. Probation officers
Yes, I know.
change and we never have problems because people pick up the slack. But, so when was the last time she reported?
Earlier in the year.
Yeah, speak up so you can,
January.
in January. Oh, okay, because she was placed on probation on January 23rd.
No, it was.
Mhm.
But I report that I have it is for February the 21st.
February 21st. Is that right?
Yes, sir.
Okay. So she was on absconder ever since then.
Yes.
Okay. And then I get from Ms. Rogers an administrative hearing in or order or motion stating that as of May 9th, 2023, May 9th, that would have been going on, let's see. February, March, April, May, going on 4 months, the defendant had not reported. And although she must have reported on March 21st, because allegation 2 here, Ms. Johnson states that on March 21st of 2023, right in the middle of the COVID situation that you're talking about, that you tested positive for cocaine
Yes, sir.
on a urine sample. Is that true or untrue?
Yes, sir, it's true. I thought I was in trouble, so I didn't know what to do. And then,
So you just go,
no, I've not.
if you're in trouble, you go buy cocaine.
No, I wasn't that.
Is
I
that,
did have, before I got on probation, I did have a problem with it. I just got scared, and sometimes when I'm scared,
go buy cocaine?
I do so.
Okay, well, that has consequences to it that are severe, man.
Yes, sir.
All right. Are you pleading true then to allegations 1 and 2 of
Yes,
this
sir.
motion to revoke probation
Yes, sir.
voluntarily and because those are true?
Yes, sir.
You understand by pleading true, that is enough to grant this motion to revoke probation. Your probation can now be revoked. You can be sentenced
Yes,
to stand by to no less than 2 nor more than 5 years confinement in prison.
yes,
Knowing that, you insist on pleading true today.
yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir.
Stand by just a second. The probation office in its administrative hearing to me, the officer stated that you made since being placed on probation in January, you have made no notable progress in coming
paid off
in.
some-
I'm sorry, and I'm going to add, you interrupt, and that's rude. Don't add that. That you made no notable progress in coming into compliance with the conditions of probation. you reported sporadically and now have appeared to cease reporting altogether as you reported in person on 3/20,
Yes.
which they tested you for drugs and that came out positive for cocaine that you have pleaded true to. So this COVID situation that you're trying to assert, number one, you don't have COVID forever.
No,
And number two, I know the doctor is not prescribing cocaine
no,
for your COVID. So that's a problem. All right, now, what shall we do?
She has asked me to request the court to consider reinstating her on probation and getting her into some kind of drug treatment program. She's acknowledged here before the court today.
Pre-sentence report?
She's
Go ahead.
acknowledged before the court today that she's got this drug issue that pops up. She thinks she had it whipped, but obviously she didn't as of March of this year. So she's asking the court to consider reinstatement.
See, you,
with-
in 2006, not to interrupt you there, I was looking at the pre-sentence report. In 2006, you were placed on probation for illegal possession of controlled substance. You were revoked in 2008 and sentenced to 2 years in prison.
it wasn't my drugs. It really wasn't. That's the reason why I started using, sir.
That was in 2006. Okay, pull that judgment up for me real quick. It looks like it's, I don't know. It doesn't show a cost number. Then in 2018, you pleaded guilty to illegal possession of controlled substance and you received 180 days in the jail in 2018 on that. In the probation office. How old are you now? I hate 38. All right. Probation office prepared this pre-sentence report on this case that you're on probation for here.
Yes, sir.
And this states that you started using K2, which is not a good thing, at the age of 22, and you were using it daily until 2019. So that would have been about over 10 years of daily use of K2. Is that true?
Yes, sir.
You don't think that's gonna make you goofy?
He said good.
Well, it's not funny. I mean, there's nothing funny about this. I mean, you think the people who use heavy equipment and fly planes, that they're using K2 every day? No, just this one. All right. On going back on this illegal possession in 2006 here. Well, this is in front of Judge Gist, wasn't?
Yes, sir.
Okay, what did you want to say about this?
I was riding in the car with somebody and they didn't claim their drugs. And that's the reason why I started using crack cocaine. And I'm
You pleaded guilty to.
I had no choice. I didn't know nothing about.
Yes,
the
you
law.
had choice. You were.
I didn't know nothing about. The law.
I'm sorry. Hold on. Mike Van Zant was your lawyer. He was a very. Are you going to badmouth him?
I'm not. I don't.
No,
Yes,
Mr.
I
Ba-
did because I didn't
Right.
know, Judge. I didn't know nothing about the law, and I didn't know that if I could fight that case,
You didn't
if it
know
wasn't
anything
my,
about the
if it
law.
wasn't my drugs, I was green to getting in trouble. I just wanted to hurry up and go home.
Well, when you, I'm sorry, in 2006, how old would you have been in 2007?
21.
You're old enough to know.
Now I am
Oh, you're not? You're not, you've been an adult for 4 years.
in trouble. That was my first time ever getting in trouble.
Is that right?
Yes, sir.
Well, let's see.
First time ever getting in trouble. I've never seen an inside of a courthouse or nothing. That was
Yeah,
my
but you were
first time.
represented.
I didn't know. I didn't know.
Well, hold on. How old were you again?
I was almost 21. I'd never been in trouble. I've never been in trouble in my life.
Well, hold on. It says that you were using cannabis when you were 15.
No, I wasn't. That's
Just
a
what you
lie.
told the probation officer.
No, that's a lie.
Okay, that's a lie. Okay. I'm sorry. Cocaine, when you were 21 when you started using cocaine,
That's when I caught this case, yes, sir.
and then you pleaded guilty. You pleaded guilty here to this case. You had a lawyer representing you, and they placed you on probation. Given you, in fact, it was a very good probation. It was deferred, where you weren't found guilty and given a second chance. And then
My grandmother, sorry.
you're interrupting. Hold, stand by. You're gonna get a chance to talk here. So you were placed on probation December 18th of 2006. And you failed to complete the required Texas Jefferson County Women's Center, which is to help you with your issues. And apparently you didn't
My grandmother.
do that. And then your probation, let's see, when was that motion filed? A motion was filed on 11 months after you were placed on probation. And then Judge Gist you were revoked, and then you were sentenced to 2 years in prison, which was the minimum. So, and all of this were pleas of true. You pleaded guilty to the indictment. They placed you on probation, and you pleaded true to failing to attend and complete the Texas Jefferson County Women's Center program that was there to help you. And so you were convicted. Then you have this illegal possession of a firearm by a felon that you were charged with on in June of last year. You pleaded guilty there on January of this year, and right out of the box, you absconded and then got caught with cocaine in your system within a short time of being placed on probation. But it's not your fault. Is that your?
That is my fault. I
right.
didn't say that wasn't my fault.
All right.
I could take.
I want to know what it is you want to tell me now. Go
I said
ahead.
that it wasn't my, I understand that, yeah, I chose drugs when I got in trouble, but the first time I got in trouble, it was not my fault. I didn't know that man had them drugs in that car.
But we're not talking about, that's history now. We're not going to relitigate that. That's all done and
But that's.
finished. No, you're on. We're talking about your probation now.
I messed up.
Okay, you messed up. All right. So here's the question.
Wait,
What should we do?
can I go to the Checks DDI program?
We gave you a chance already. What shall we do? What states?
Your Honor, state asking for 5 years. At least she's already been given a break by limiting it to the 5 years instead of the 10. And like you said, within 2 weeks of her being placed on probation, she starts failing to report. Within 2 months, she's tested positive for cocaine.
Okay, Mr. Dusler, what do you think?
You're all right. Again, it's a difficult situation because it's obvious by her remarks today and the way she presents herself. That she's got a drug issue, that she's also got
Yeah, but
issues.
you can't, but she's got an opportunity. Are you gonna interrupt during this whole proceeding? Or are we gonna have to put like a mask around your mouth so you don't talk? We learned that when we were in first grade. Our teachers corrected us.
You already said you're giving me 5 years.
Anything else you want to say? You've interrupted everybody.
Okay.
That's not right. You get a chance to be heard. I haven't made my ruling
It's
yet.
not gonna work because you made your
All right.
decision already. Please, I'm an MHMR patient, okay? I take medication in the free world, okay?
You know
I'm
what?
sorry, sir.
All of us are
I didn't
imperfect
take my
people.
medicine this morning because the jail didn't.
Here's what we're
give it
gonna
to
do. You're going back for timeout right now.
I don't need
You're
to
not- Go on back.
My
When you can resolve, when you can get to your composure, we'll bring you back out. We've got other things to do right now.
time, please.
No, we got other things to do where people are more composed than you. Sorry. And your cursing just got you
In the
in
matter
trouble.
of the state of Michigan versus Paris Clegg, 231321. And appearance, counsel?
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client's timely consent to the matter being heard via Zoom. As to the sentencing, we've had an opportunity to review the pre-sentence investigation. It's factually accurate.
Okay. All right, and Mr. Clegg, I feel like you were just here, but has it been a month already, or were you just here last week?
No, it's been a couple weeks.
Okay, I don't know, it seemed like it was just last week, I don't know. So, all right, and sir, you have a lot of warrants out for your arrest.
Yes, I'm currently taking care of it now. I'm on a work assignment through my job, well, through Segway. So they have me working at a gym right now, but I'm going through a case with my lawyer as well with them, so I'm just trying to figure it all out right now. But my lawyer is helping me take care of the warrants and stuff right now.
Okay, and you have a lawyer for what matter, sir? Other than this matter, you have a lawyer for what?
An injury I've sustained at work.
Oh, okay. Was that from a while ago or recent?
No, it was from April.
Okay. All right, and sir, I know that you stated that you, oh, I'm sorry, what's that?
I couldn't hear you. I'm sorry. I thought it was muted or something.
Oh, no. You indicated that you had one beer on the night of the offense, but I'm pretty certain, given your level, that you had more than one beer, right?
No, I had one beer.
One beer, and then
I'm certain. I know it was one beer. My wife knows it was one beer. And I drank it hours before I even took my kids to the park.
to where?
Can you hear me?
Before you took your kids to where?
To the park. It's a water park, like 5 or 10 minutes up the street from you all. I got pulled over directly across the street from the police station.
The water park, the one, the YMCA?
No, there's a little outside water park right down the street from you all.
Oh, do you mean the fountain?
It's like a little splash park for kids.
Oh, okay. Okay. But sir, so your level was still a 0.11, and so I just want to make sure that we're all on the same page. And what's your wife's name?
I can't hear you.
What is your wife's name?
Swella Bell.
Okay. And sir, where do you believe all of your warrants are? You have the attorney that's helping you do that.
You said what?
Your warrants. What
Yes.
cities are your warrants in?
Dearborn, Inkster, Westland, one out of Detroit when I was 17. A bunch of old petty little traffic warrants that I may need to take care of, and some stuff that's already been taken care of. I just probably need to just show face again in court in order to get it removed from my record or whatever they're gonna do.
Make sure you're adding Allen Park to that list. You're adding Romulus to that list. Taylor, Southgate.
I know all of those things, ma'am. Again, I'm trying to take care of it. I have not been in the right spot in life, and I'm getting behind it now. Obviously, I'm working. I'm at work right now.
I understand that, sir. I just want to make sure that you are aware of all those, not just the ones that you stated the cities on. So here's what the court's going to order. I'm sorry, what's that?
I said, I'm aware, again, it's already being taken care of. So it won't be a problem. It won't be an issue.
Okay. All right, the court is going to order on your plea to an amended charge of operating or visibly impaired and driving a license suspended. The court's going to state that after hearing from counsel, Mr. Clegg, reviewing the report, the recommendation that there is reasonable grounds to Brooklyn MCL 769.5. 18 months probation, you are eligible for early discharge. And I'll go over that in just a little while. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're to notify your probation officer immediately for any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. The court's going to also order you to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is to assist you in providing coping mechanisms so that you may maintain sobriety and prevent relapse, hopefully preventing this matter from happening again in the future. You'll have to participate in the MAD victim impact meeting. The rehabilitative goal for that condition is to further increase your understanding of the dangers of driving while under the influence and to educate you about the consequence of such behavior. The court's going to order 7 days of the court workforce. That's the rehabilitative goal for that condition is to help you further develop work and life skills and get back to the community. The court's going to also order you to obtain a valid driver's license, to attend a parenting class. The rehabilitative goal for that condition is to teach you further how to deal with daily responsibilities of maintaining a positive home environment and ensuring the children's health and safety.
Ma'am, I don't mean to cut you off, but my kids were taken from me, so I don't feel that I need any parenting classes. When I got pulled over that day, they took my truck and they took my kids. They mom not letting me see them. I have not seen my kids since August, and I told the judge there that I don't even want to be involved in it anymore. So I'm not even going to see them again anyway. I'm planning to move out of Michigan as soon as I clear up my warrants and clear my name. I broke up with my girlfriend, the one I was with at the time. So she lost her car. So again, I'm just really trying to clear up every mishap that I have in Michigan so that I can never come here again.
Okay, so I'm sorry, please back up. You stated that after this incident that the children's mother has not allowed you to see the children.
At all. I have not seen my daughter since April 24th, the day that I got pulled over. I mean, August.
Okay.
I have not seen them at all. Again, okay. I'm not what I went to court already.
Sir, please let me finish. Is there a court order that orders your parenting time to be suspended?
Yes. CPS. Child Protective Service. They came to my home, everything.
Okay. And so is there a pending case with CPS?
No, I have an open case for CPS, which they are telling me now that I'm not able to see them. I don't have any visits at all. So again, I'm not even going to deal with that anymore. I grew up without my father, and hopefully me working will be able to support them as much as she'll need. Because I won't do this going back and forth to court or jail about it. So that's just done. That's why I said I don't need a parenting class. I don't have any other children that I have a problem with. My oldest daughter lives in Ohio. I pay child support for all of my kids. I don't want to be a part of their life. I already discussed this with the magistrate judge down there. So I really don't feel that I need to do that. Anything else, I'll do just on the strength of, because I'm just trying to clear it up and get it done so I can leave. Honest to God.
So you don't want to be a part of your children's lives at all?
No.
All right, well, until I have something.
Not that I
from
don't
CPS
want to. Not that I don't want to. She's not allowing me to, and the state of Michigan is allowing her to do that. So where do I win that fight? Again, I grew up without my father. I'm pretty decent.
Sir, you have an attorney appointed to represent you down there, correct? For the CPS
Yes.
matter?
Yes, and he's not doing anything. Obviously, if I have not seen children, we just passed holidays, got more holidays coming up, birthdays, I just missed everything. So obviously he's not doing anything in order for me to see them again, and she won't let me see them. So, and I can't contact her, or that's going to be violation basically of me just asking her, can I talk to my children? So I don't even want to deal with it again.
And sir, is that all as a result of this case here?
Yes. 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 I broke up with the girl that I was with. She lost her car. I lost my kids and a bunch of other stuff in the long run. So again, I'm just trying to do what I have to do to initially leave the state of Michigan and start a brand new life. And I won't have to ever deal with it again.
And so you don't want to, so the CPS generally will put forth conditions by which certain things you have to follow, and then you would be able to be reunited with your children again. And
but again, it's always going to be a problem with their mother. So
Sir, you chose to have children with her, so that is what it is. And so because you don't like what she's, how she's, sir,
I'm the
you don't
one
like how
with
she's
jail. I'm the one who went to jail for child support. I'm the one for child support.
Please interrupt me. So because you don't want to deal with the mother of your children, you're going to just step out of their lives. That's what you're saying?
I'm already living another life. That's what she's mad about. We haven't been together for the last 5 years. My oldest daughter with her is 6. I have 2 daughters with her. We haven't been together since the first one was born.
You haven't been together since the first one was born, but yet you had another child.
I want to be the one continuously in trouble, having to pay child support, having to go to jail for child support, back child support, having to get arrested when she comes to my house and makes a fool of herself. All that type of stuff I can do without in my life because I don't need it. So that's simple. Like I said, I grew up without my father. I didn't turn out all out of whack. I'm okay. So again, the child support that they're asking, I hope that's enough for her to support the children, because that's all I can do. I don't feel that I need to even go deeper into it, because simply there's nothing that me, neither you or anyone else can do. If it's been since August and I've been calling courts and I've been talking to the magistrates, I've been talking to different people down at the Penobscot building, no one's told me anything that I could possibly do to just get a 10-minute visit with my kids, even at a McDonald's, anything that would allow me to see my children, and no one's been able to help me at all. So again, I would rather not and know that I didn't. I'm not gonna keep on continuously putting myself at fault. I'm a good man. I'm raising a child that's not even mine. I've been raising him for 5 years. He's been doing well. CPS came out to my home. They checked my home. They made sure everything was legit. So my case is probably initially going to get closed anyway, but I still don't want to deal with the after effect of what's going to happen with her. just for me trying to see my kids and be there to be a part of their lives. So it's something I don't want to deal with. It's only going to drag me down for the rest of my life.
Well, the court is going to continue that condition unless I receive an order from the Third Circuit Court or CPS that suspends or terminates your parenting time. So I will amend that condition once I receive that documentation. The court is going to also order that you are to clear up your warrants and mandatory jail for any violation.
Mandatory jail for any violation.
So that means if you, if something
know
shows
what
up positive on your drug test, or you don't appear for drug testing, or you pick up another case somewhere, or you're not clearing up your warrants, you know, things like that, then that would be jail time. Any other questions, sir?
No.
All right, the court will know that this is as to, that these conditions are concurrent. The court's going to order as to the operative or visibly impaired a $300 fine, $100 screening assessment fee, supervision oversight fee of $900. That's $50 a month at 18 months. And since you're eligible for early discharge, up to $450 of that may not be due. $200 for the cost of prosecution. Crime victim assessment fee of $75. Justice system assessment fee of $50. Workforce of $280. And so that total is $1905. And then as the drug and alcohol license suspended, the court's going to order a $500 fine, cost of prosecution $100, crime victim assessment fee of $75, justice system assessment fee of $50, which will $725. Total between both is $2,630. And sir, did you post a bond?
Yes, I did.
Okay. All right. And so you can apply that bond, and then do you have any other money to pay today, sir?
No. No.
Okay. And so how much are you able to pay per month? And what day of the month works best for you?
I'm gonna be all the way honest. The place where I'm living now, I'm on my last limbs, and I don't pay anything here. I work at a gym at the front desk. I'm barely making it.
Okay. And how many hours a week do you work, sir?
I can't hear you. I'm sorry, I couldn't hear you.
How many hours a week do you work?
20 to 40 hours. I'm working at a volunteer gym for veterans.
I understand that, sir. I understand that. I read your report. And so are you working anywhere else to?
No.
Okay. And your girlfriend works?
Yes, she works.
Okay. You
But
$20 a month, sir?
Do with what I'm doing. She's
What's that?
just barely giving me somewhere to stay. So that has nothing to do with what I have going on.
So I was simply asking to see if you're responsible for 100% of the rent or part of the rent. I
Yes,
understand that she's not responsible for paying your.
$600, $600 a month plus utilities, which is about probably 100 and something.
Okay. All right, can you do $20 a month, beginning next month?
Yes.
$20 a month, beginning January. I'll indicate January 12th for your first payment. And as I did indicate, sir, you are eligible for early discharge so long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort toward making full payment. All right, so please email into probation as soon as you disconnect here, and they will get you set up with an appointment to get your terms and conditions.
I need to do what?
You need to email into probation so they can get you set up with your terms and conditions, sir.
Email my information?
You need to email into probation.
Email to probation?
Yes, so they can get you set up with your terms and conditions.
Okay,
Okay.
can you let my attorney know so he'll be able to text me or guide me on how to do it or whatever? Because
Okay, Mr. Shumke,
Yes, Your Honor.
would you mind please emailing or messaging Mr. Clegg with the email for probation, please?
Yes, Your Honor.
All right, thank you. We are going on the record in the matter of the City of Wyandotte versus Autumn Bulchak, 232-479, 23739, 23405.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom. As to the arraignment, we waive formal reading. My client stands mute.
All right, and Ms. Bulchak.
Yes, Your Honor.
Your name, please, for the record.
Autumn Bolchak.
All right, and so counsel, let's handle the most current matter because the other two matters are probation violations. So, as to the current allegations, you indicated your client was going to waive the formal reading. Is that what you indicated?
Yes, Your Honor. I've gone over the charges as well as the violations. We are prepared to move forward. No formal reading required on either proceeding.
All right, and the court will waive the formal reading, enter plea of not guilty for purposes of the arraignment, schedule this matter for a pre-trial on December 19th at 9 a.m. And as to the probation violation, counsel, would you like to set these for the same time, same date and time?
Yes, Your Honor. Yes.
The court's going to enter pleas of not guilty on these violation hearings. And set these for December 19th at 9 a.m. And just for the record, these are on case number 23405. It's alleged that she failed to appear for probation visit on June 15th, failed to register and begin drug testing as ordered, failed to comply with any conditions of probation. And then also on the 23739, failed to appear for any probation instructional on June 15th and June 22nd. Okay, and counsel, as to bond.
Your Honor, we respectfully request any consideration towards leniency. My client's apologetic for not being in full compliance. She's 26 years old. She's responsible for a 3-year-old girl. She lives in Wyandotte. She indicates she will appear at any and all future court dates. She's deeply apologetic for not complying with terms, conditions, and obviously it's our hope to potentially find a resolution at the next court date and potentially have some probationary terms run concurrent with her new case. But she is hopeful to be in full compliance, and she indicates that she would be very interested in seeking some treatment going forward. Thank you, Judge.
Okay, ma'am. You're telling this court that you have custody of your child?
No, I do not.
I'm sorry, what's that?
She does not have custody. Currently, the child is with the father, but she would like to regain being an active parent. But no, she does not have custody of the child as present.
Okay, and so how often do you see the child?
I haven't seen her.
And how long?
Almost a year.
Okay, but you told your attorney that you're responsible for your daughter, correct?
I
To
told
the
my
extent,
attorney
Judge, that
that
she
I
would
do
like to
have-
be responsible. So I'm sorry if that's a mischaracterization. She would absolutely like to be reunited and again, take on the responsibilities of being an active parent, Judge. But no, she did not mislead.
Okay,
I don't think I'm qualified yet to be an active parent, but I did say that I do have a biological daughter that is she'll be 4 in January. That I did say.
okay, ma'am, well, what would be in your system if you were tested today?
What?
Yeah, what would be in your system if you were tested right now?
Nothing.
Nothing.
No.
Ma'am, you were sentenced on your other matters. Sorry. On April 5th. On the 405 matter. And then on May 30th, on your 739 matter.
Correct.
And ma'am, you're saying that you want treatment.
Yes.
Okay, you were in treatment just 6 months ago.
Yes.
Okay, and so how long ago did you relapse, ma'am?
Probably a few months ago.
Okay, so what I'm going to order is on 232479, based upon your failure to appear on your other matters in this court, your failure to do anything as it relates to probation, fail to register for drug testing, fail to even appear for your probation visits, fail to comply with any terms of condition, and the fact that you're on probation for 2 matters that are similar in nature to these matters, the court's going to order a $7,500 10% bond. In the event you post bond, ma'am, GPS tether to the Wayne County Jail. And in the event you request treatment while you're at Wayne County, you may be tethered to treatment.
so I can bond out. So if I place bond or post bond, then I'll get a GPS tether.
Treatment, yes, to treatment.
And what happens if I don't post bond?
You'll be in the Wayne County Jail.
For how long?
Well, at least until your next court date on December 19th.
And where's the
And then they
treatment
have
center
to-
to?
I'm sorry?
Where does it say that I'm being placed to treatment at?
And if you are in custody and you are at the Wayne County Jail and you are requesting treatment, then I've made a note in there that then they can tether you to the treatment facility.
That they can tell me a treatment facility?
They can tether you to treatment facility.
Right, I'm just wondering which place it was.
I don't know, ma'am. There is a variety of them that they utilize. I don't know.
So I'm going to jail?
Yes, ma'am, you're going to jail. And on 23405, $5,000, 10% bond.
How much is that?
$500.
And 7,500 for the other one?
Yes. And then, just while you're doing your math on 23739, it's gonna be another $500 because this court's gonna order another $5,000, 10% bond on that one as well. And GPS tether, you got your post bond. And again, you're not to possess or consume the alcohol or drugs unless prescribed.
Ma'am, there's no way I can get out of jail today?
Absolutely not, ma'am. You have not even contacted the court here, made any attempts over the last number of months. Nope, not at all. And then now you're back in custody for the exact same thing you're on probation for, so no way.
Ma'am, I'll never do drugs again. I'll never bring them to Wyandotte again. I just want to be back in my baby's life. I just want to be with my baby father. I just want.
Ma'am, right now you're not in any condition to be in your child's life, and you even acknowledge that. So not happening.
I don't want to go back into the system. I don't think that it's right for me. It's not. Last time I was in there.
So when you're at the Wayne County Jail, you can request to be sent to treatment. And I've made a condition that you can be tethered to treatment upon your request.
So as soon as I get there, I can request to go to treatment? That's what you're
I'm not
saying?
sure how that works. I don't know at what point you can ask for that, but yes, upon your arrival, go right ahead.
And I'll have to wait until my December 19th court date?
To appear back in this court, yes.
Okay, how many days, Your Honor, are you saying that I have to spend in Wayne County?
Well, ma'am, today is the 4th, and the next date you'll be here is the 19th. So that's 15 days.
And do I have the opportunity to so the only way I can get out is if I post bond?
Ma'am, let me be very clear. If you post bond, you're going to have a GPS tether, and then you are going to be tethered to treatment. So anywhere you slice it, you're tethered to treatment, not back to your home.
Right. So I'd rather just wait it out?
I can't tell you what to do, ma'am. I can't tell you what to do.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
All right, thank you. Okay, let's go off the record.
All right, the court will hear argument state.
Judge, here's this case, the defendant was already on probation for 3 separate cases, 2 misdemeanors and 1 felony case out of this court. On the night of the offense, there were several reports of a car facing the wrong direction, on the wrong side of the road. When the officers actually spoke to the defendant, almost immediately he was intoxicated. It's not intoxicants.
Excuse me, you all need to be quiet in the box. We're on the record.
He had bloodshot eyes, and whenever the officers attempted to begin the SFSTs, they couldn't actually continue with it due to the fact that the defendant was so intoxicated that risk to himself just inattempted. The defendant admitted to consuming alcohol, and when the blood was tested, when the defendant's blood was tested, it came back as a 0.258. Additionally, Your Honor, the 2 misdemeanor cases that he was on probation for out of 2045 were DWI cases. On those cases, he was ordered to have a ignition interlock, which defense did provide a record of. It's a different car than what he was seen driving on that night. Again, the main concern here is just this, is that the state has that he was already under supervision when this happened. And again, he was trying to get around the terms of his previous probation by driving a different car, which is something that he's not allowed to do. That's why the state was asking for 5 years.
All right. Defense.
And Judge, we just asked that the court take consideration of the PSI that was done. Mr. Vargas comes here to this court today motivated for treatment. He does have a 13-year-old son. He's a very active part of his son's life, and he acknowledges drinking that evening, and I believe he acknowledges making a mistake. He also tells the officer in that report that he wasn't on the current medication program he's on now. Because of his willingness to accept responsibility for this, and in addition to that, Judge, his willingness to be ready for treatment, we would ask the court deny the state's request and grant him community supervision. That will be a felony conviction on his record. He will have to report that, and that the court order whatever treatment option it feels best necessary to protect Mr. Vargas and society.
All right, so Mr. Vargas, you didn't make mistakes. You're making choices. You're making choices to drink. You're making choices to drink and drive. Obviously, you are addicted to alcohol. Obviously, you can't stop drinking. Hence, that's the reason why you're in felony court. So you're not going to leave here today. I'm going to give you a choice. And sometimes I can give people choices, sometimes I can't. You're going into inpatient treatment. And if you make that your choice, then your underlying punishment is not going to be 5 years. Your underlying punishment is going to be 10 years. And you will be on probation for 8 years. So, or I can sentence you to 5 years prison. Which do you prefer?
The alcohol.
Okay. So the court is going to find you guilty. The court will sentence you to 10 years in the prison, suspended and probated for 8 years. This is run concurrent with 2018 CR 13260, County Court Cause number 594501 625188. There's to be no driving for the duration of this probation. There are to be no vehicles at your residence. So I don't know where they're going to go, but you cannot have any vehicles at your residence. There's 2 years driver's license suspension, victim impact panel live, DWI education. There's to be 10 days in the Bexar County Jail as a condition of probation. He's to be evaluated for safety. And did he qualify for DDRF or no?
I believe it was referenced in the PSI. There was a recommendation for DDRF.
All right, we'll have him evaluated for DDRF. And there's to be a referral to felony drug court. And just have them to put him on the waiting list. There's to be regular reporting. Field visits. Random. 2 times per month. Needs to do scram. Proof of employment. Within 30 days of release. There's to be no employment as a home health care provider or with minors. Parenting classes. 200 hours of community service restitution, 40 of those hours will be waived. If you provide proof of the COVID vaccination, the court is not requiring that, but if you do 40 of those hours will be waived. The remaining hours will be waived once you complete parenting classes. I'm gonna want sober meetings. And I'm gonna want 90 meetings in 90 days. Probation, is there anything else he needs? Is there anything else you need from the court to remain clean and sober?
No, Your Honor, and I will take any suggestions, but thank you.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Understand.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. We're next going to proceed on cause number 2018 CR 13260. I believe the defendant previously pled to violation of condition number 1.
Yes, Your Honor.
All right. With regards to this case, the court will deny the motion. Alternate main conditions to extend for 1 year with all previous conditions. Is there anything else from either side?
No, Your Honor.
All right, we can go off the record. Mr. Vargas, let me just explain to you why the court did what it did. It's obvious to the court that you have an alcohol problem. Misdemeanor court obviously couldn't solve your problem. This is your chance to get your life in order. If you come back before me, you're looking at 8 years in the prison. And when you come back before me, if you do, you cannot say that you were not given the tools you needed in order to remain clean and sober. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Your Honor.
You're welcome.